I just want to give a special thank you to our partners who helped us get the word out about this event, and to our speakers, to the Law Foundation for partnering with us to get this really important information out about this new law. This presentation is going to be in English only. We're going to offer this in Spanish at a later date, but tonight will just be in English only. I'll have a survey that I'll throw into at the end of the workshop that it'd be great if you could fill out. Just give us some feedback on the workshop, and then we can also send you a copy of the presentation if you'd like, and you can elect to do that in the survey. I'd like to just go ahead and introduce our speakers. Tonight we have joining us from our organization, Emily Hislop, who's our Rent Stabilization Programs Manager, and Charlene Kilgore, our Housing Counseling Director. So we are all from Project Sentinel. We're a nonprofit housing service agency serving communities in Northern California. We offer landlord-tenant counseling, dispute resolution. We also do fair housing services and HUD-certified counseling, as well as home buyer, mortgage, foreclosure, and financial credit counseling. And then we also have Michael Trujillo, a staff attorney from the Law Foundation. We work with the Law Foundation. We refer a lot of people over to the Law Foundation. They provide free legal advice and representation on housing-related issues to low-income families and individuals in Santa Clara County. They also do a lot of education around landlord-tenant law, and we're happy to, again, to have Michael here tonight. I also want to mention that we have one of our case managers, Mark Thomasy, in the audience tonight, and typically there is a workshop held monthly for Milpitas, and he's offered that if there's any Milpitas people in the audience who'd like to stay on after our presentation, he's happy to stay on and share some more specific information about Milpitas rules and regulations. So here's what we're going to go over tonight. We're going to go over the COVID-19 eviction protections, what to expect and what to prepare for, and then Charlene's going to talk about small landlord mortgage relief options. And I'm just going to do a quick poll and to see what our audience looks like. I have, if you wouldn't mind filling this out, I'd like to see how many owners and tenants we have in the audience. Great, well, thank you for doing that. It looks like we got about half and half here tonight. So glad to see that we have both tenants and owners in the audience. Will be speaking to both of those audiences, sharing the information about what protections and responsibilities are involved in the AB3088. So thank you again for doing that. And I'll go ahead and hand it over to Michael so he can get started on his portion. Thank you very much.
Elizabeth, do you want to mention for people about the Q&A?
Oh, yes, thank you. Yes. So we have a Q&A function here. So if you have a question during the presentation, please feel free to put it into the Q&A, and we'll answer it at the end. We'll also have the option of doing raising your hand at the end and allowing you to speak your question. We encourage you to get those questions out as they come to you during the presentation, but again, we won't answer those until the end of the presentation.
Let's see. Alrighty, thank you. Well, I'm Michael. I'm a staff attorney at the Law Foundation of Silicon Valley. I want to start by just thanking Project Sentinel for helping us get the word out about the eviction protections that are in place right now. There's a lot of action that has happened in recent weeks, both at the state and federal level. And so it's really important that we spread the word about what the rules are right now and how tenants are protected against evictions. So the first thing I want to explain is that in California, landlords always must go to court in order to evict a tenant. There's no such thing as a self-help eviction, and landlords can't take it upon themselves to lock out a tenant, change the locks, or throw their stuff out. So before every eviction case, a landlord does need to provide a formal written notice, and the tenant will have a chance to respond. But the important thing to remember is that the tenant can't be locked out until you've actually gone to court and the landlord has gotten a judgment in their favor from the judge. On the tenant side, the important thing to know is that if you do get one of these written notices, an eviction notice, that's your opportunity to go get help. And as soon as you get that eviction notice, that's when you should be calling us, calling Project Sentinel to learn about your rights and figure out the best way to respond. Hopefully you'll have some idea as to how to respond after our presentation tonight. All right, so the first protection that I want to talk about right now in terms of COVID-19 specific eviction protections is the new state law on evictions, and that's AB3088. So let's see, I think I may have hopped ahead here a little bit. Okay, so as an initial matter, the new state law on evictions, AB3088, basically puts a pause on all kinds of non-payment evictions until October 5th. So, the courts really aren't processing non-payment of rent evictions until then. After that date, the law kind of splits up the protections for non-payment of rent evictions into two different periods. So there are different rules for rent that was due before September 2020 and rent that is becoming due in the next few months until January of 2021. And we'll explain what those different rules are here in just a moment. But generally, tenants are protected from eviction if they have lost income or have had more expenses due to COVID-19. And I'll talk a little bit more about how to actually explain that you've been evicted and claim the protections, how to tell your landlord that you've been impacted by COVID-19 and claim the protections, as well as what actually qualifies in terms of COVID-19 impact. So with respect to non-payment of rent evictions, as I mentioned before, the law creates two different sets of rules for two different time periods. So for rent that has become due kind of up until now, from March 2020 when the COVID pandemic really began in California until August 2020, tenants can never be evicted for having not paid that rent. And however, for rent going forward, rent from September 2020 until January 21, tenants do have to pay 25% of their rent in order to be protected from eviction. And if they pay that 25%, they can never be evicted for the remaining 75%. Now, tenants, for both periods, tenants still do have to pay rent, even though they can never be evicted for that rent from March to August. They could be sued in small claims court if they don't pay that back in time. And the Law Foundation, it's our interpretation of the way the state law interacts with our county law, that tenants will have until February 28th, 2021 to repay any, to repay 50% of the debt that they owe from March to August of this year. And then until August 31st of next year, August 31st, 2021, to repay all of that rent that they owe from March to August of this year. Now, as I mentioned before, if they don't meet, the tenant doesn't meet those deadlines, the landlord's option is to sue them in small claims to recover that debt. Now, for the rent period that we're in now, from September 2020 to January 2021, tenants do need to pay 25% of their rent, but they only need to pay that by January 31st. So this means that a tenant can make, a lump sum payment of, what comes out to 125% of 1 month's rent. That's 5 months times 25% of the rent. At the end of January, they could do that. If tenants do want to pay, the 25% on time, we recommend that the tenants actually write in on the memo line, what that payment is for, so that's clear for landlords and it's applied correctly. And again, if the tenant does pay that 25% of their monthly rent from September 2020 to January 2021 by January 31st, 2021, then they can never be evicted for the rest of the rent they owe from that period. The landlord can still pursue that debt in small claims court, and they can do that starting on March 1st of next year. Sorry, we're having a little bit of difficulty. I'm trying to remote control the slides, and I think there may be a delay on my end, so I appreciate people's patience with our technical difficulties. So if we could go to the next slide. Thank you. All right, so in terms of how tenants let their landlords know that this new law applies to them, and they should be protected from eviction. The way they do that is through a self-declaration. So this is a form that landlords have to include with any eviction notice for non-payment of rent. And what the tenant has to do is sign that form stating that one of the statements on that form as to how they've been impacted by COVID-19 applies to them. Tenants do need to return the form within the 15-day period for that notice of non-payment of rent. And as I mentioned before, the landlord does need to include a copy of the form with any notice of non-payment that they provide to tenants from now until February 1st of 2021. So from the tenant side, really the best thing to do is to look out for notices of non-payment of rent, and every time you get one, send back a signed copy of the form. Landlords are permitted to send their tenants a notice of non-payment of rent for each month from now until January 2021. So it's important that tenants, reply every time with the signed declaration. And if there are tenants that are making more than 130% of the area median income, they may need to supply additional documentation as to how exactly they've been impacted. So in terms of what actually counts as a COVID-19 impact, this can include both loss of income or increased expenses. And there's several factors listed here as to ways that a tenant could be impacted by COVID-19. And these are actually match the statements that you'll see on the self-declaration form that you use to let your landlord know, that these protections apply to you. So we'll go through some of these. So the definition of COVID-19 impact does include, of course, any loss of income, whether that be, actually losing your job or having your hours cut back. If you're self-employed, that can include canceled orders or, a lower volume of services related to the COVID-19 pandemic. But increased expenses also count as well. So if you have increased out-of-pocket expenses, maybe related to travel or childcare because of your need to continue doing an essential job during the pandemic, that could count as COVID-19 impact. Certainly any health expenses directly related to COVID-19 qualify, as well as time that you've taken away from work or increased expenses you may have had because of a duty to care for children that are home from school because of COVID-19 related closures, or any elderly, disabled or sick family member who's been impacted by COVID-19. And finally, there's this kind of catch-all on the declaration that includes other circumstances related to the COVID-19 pandemic that have reduced income or increased your expenses. So it's meant to be broadly accessible. And again, tenants only need to sign the form stating that one of these situations applies to them and send that back to their landlord in order to be protected. There's no need for the tenant to, write an explanation as to what happened to them, or, provide a budget, or even provide documentation like a letter from their employer. All the tenant needs to do is sign that declaration that's provided with the notice of non-payment of rent and return it to their landlord within 15 days. So the last point that I'll make about the new state law on evictions is that it does add some protections around the types of evictions that can go forward. So until February 1st of 2021, next year, the law prohibits landlords from giving tenants a no-cause notice. So this means that every eviction notice provided to tenants does have to include the reason for the eviction, and those evictions can only go forward if that's for what's called a just cause, basically something that the tenant has done wrong. However, a tenant, for any of those causes, basically where the tenant has at fault, the landlord does need to provide the tenant an opportunity to fix the problem before moving forward with the eviction. The new state law also limits the extent to which evictions for remodeling or rehabilitating the property can go forward. Those types of evictions can only go forward if the remodeling or the rehabilitation of the property is actually necessary for health and safety of the tenants. And let's see here. Just making sure I've covered everything here. The final protection I'll mention is with respect to impact on your credit. So rent debt that you owe can be reported to credit reporting agencies and could affect your credit. However, any eviction cases and any small claims court cases that are filed or have been filed from March of this past year, March 4th, 2020, to the end of January of next year, January 31st, 2021, will not be publicly accessible and will not impact your credit. So I know there's a lot of information. There's a lot of different rules, pretty confusing to just think about, on their own, but I think an example really helps to identify kind of how this all works. So here we have Tammy Tennant. Her rent is $2,000 per month. She works at a local restaurant and had her hours cut back in April because of the county shelter-in-place order, shutting down her place of work. So Tammy currently owes about $6,000 in back rent from having not paid rent in May, June, and July of this past year. Tammy's still out of work and is worried about being able to pay her rent going forward. So the question is, what does Tammy do to protect herself from eviction? Go to the next slide. So the most important thing that Tammy needs to do to protect herself from eviction is to sign and return the self-declaration that is provided with any notice of non-payment of rent that she gets from now until the end of January of next year. Again, that form does need to be included in the notice, included with the notice from the landlord. Tammy does also need to pay 25% of her rent from September of this year until January of next year, no later than January 31st. And if she wants to pay that amount kind of each month in installments, then she should write on the payment in the memo line or in the letter included the payment, what the reason for that payment is so that the landlord applies it correctly. Alrighty, so if she does those things, Tammy can't be evicted for any of the rest of the rent she owes. So with that, I'll move on to the protections that are still in place here under our local Santa Clara County eviction moratorium. So as a reminder, this moratorium does apply county-wide, including within all cities in our county, within the city boundaries, including those cities that have passed their own eviction moratoriums. It does apply to all residential and small business tenants as well as subtenants, and applies regardless of the length of lease. Even if it's a oral agreement. It also applies to all types of residential properties, including mobile homes and single-family homes. It does prohibit late fees and interest charged for unpaid rent from March to August of 2020. And it does provide no fault eviction protections until September 30th. That could be extended if the governor extends his executive order on evictions up until November 30th. It looks unlikely that that's going to happen. There are also protections in our county moratorium for small businesses who have been impacted by COVID-19, and they're protected from evictions for non-payment of rent and for any no-fault cause until September 30th as well. The last eviction protection I want to highlight is the CDC order on evictions. And I think, the main takeaway I want to leave tenants with here is that if you think the CDC's order may apply to you, or if you think the protections that I just explained do not apply to you, if you think you fall into a gap, give the CDC's order some thought and seek legal assistance to see if it provides you any protection. So the CDC's order does prohibit all no-fault evictions until December 31st, the end of the year, and prohibits all stages of an eviction, including the final stage that happens after judgment, where a landlord actually goes to request the lockout from the sheriff. It also is a little bit easier on tenants in terms of when they can claim as protections. There's no 15-day time limit like in our state law, and there's no need for the hardship that the tenant is facing to be specifically related to COVID-19. The law also does protect tenants who are facing evictions for rent that was unpaid from before March 1st, 2020. And finally, it does include enhanced penalties for landlords that do not comply with the order. So, that's kind of a watch out for the landlords on the calls, that the penalties are quite steep for any violation. But again, so I guess just say briefly why, we encourage tenants to look first to that the state law for eviction protection is just the simplicity of claiming those protections. The form is, the declaration that the tenants need to sign is very broadly applicable. And again, it's just a signature from the tenant. With the CDC order, there are actually several factors and circumstances that the tenant needs to meet and testify actually to state under penalty of perjury that all of them apply to them. So because of those factors, it's a little bit more difficult for the tenants to claim that protection, and tenants should look first to the state law for protection. Sorry about that. So kind of wrapping this all up in terms of, what tenants need to know in terms of how they're protected from eviction. The first thing we want tenants to know right now is to not move. I know it can be stressful to have rent unpaid, but there are protections in place right now for folks that have been impacted by COVID-19. The second thing is that if you do not pay rent anytime from March to August of this past year, you can never be kicked out for that debt so long as you do, return the declaration that's provided with any notice, any eviction notice for non-payment of rent. And then the third thing is that for rent that's due from now until January of next year, you can never be evicted if you pay 25% of that total rent no later than January 31st of 2021. And again, you sign and return a declaration attesting to your COVID-19 impact in response to any eviction notice for non-payment of rent. Right. That wraps up my portion. I look forward to answering questions on the Q&A and at the end of the presentation.
Thank you very much, Michael. I'll go ahead and move the screen forward. Emily,
So,
are you?
Yeah, I'm unmuted. I'll need you to control,
Sure.
unless you want to switch it, or it might be easier. So that was just a lot to digest. So we thought we would walk through what tenants and landlords should expect. What does this actually look like in real life going forward? So next slide. So as Michael just, I think, mentioned, if a tenant has any unpaid rent from between March 4th, 2020 and the end of August 2020, by September 30th, the landlord should serve this notice to the tenant, notifying them of their rights under state law. I know that we all were doing different things were happening when there was a Santa Clara moratorium and there were other cities, but this is now state law and the state has made these forms. We're gonna show you where you can find them too. But this is what it looks like. So it's a notice, this is just the first page, and they need to give it to any tenant, even if the tenant's already supplied a declaration. So at the same time as giving this notice, the landlord might also give a 15-day notice to pay or quit. The tenant shouldn't panic, and for landlords on the call, landlords understand that there's a few different forms in order to protect your rights that you should be serving on tenants. So Next slide. So this is the 15-day notice to pay or quit. The state has a form, and this is only as it, this relates to unpaid rent between March 4th, 2020 and the end of August. So you'll see I highlighted this notice for a landlord that has tenant with unpaid rent to belt and suspenders and do everything that they can. They would serve the notice we just showed you. They would give the tenant this 15-day notice to pay or quit, which details out all the monies owed and which month and year. And in addition, they must also give the tenant this blank declaration form that covers all the things that Michael had talked about previously. As tenants, as people may note, it lists all the reasons that could be why a tenant was impacted by COVID-19 and unable to pay their full rent. You do not need to select which one applies to you. You are just signing under penalty of perjury that one of these things applies to your situation as is the reason for not being able to pay rent. So a tenant with unpaid rent during this period may get the notice, this 15-day notice to pay or quit, and the declaration of COVID-related financial distress. All state forms. All the tenant needs to do is, if they were impacted by COVID-19 financially and unable to pay rent during that period, is sign this document, date it, and return it to their landlord within 15 business days of receiving the 15-day notice to pay or quit. I made a note down there. We all have phones with cameras on them. You want to keep a copy for your own records to show that you did sign this declaration and provide it to the landlord. You can mail it to the landlord, give it to them, or if you normally communicate by email, that's another way you can get it to them too. But the 15-day notice must be served, personally served or posted and mailed to you if you're not home, just like a 3-day notice would. Next page. Okay, so that's one set, and that just deals with that first period of March through August. Now going forward, starting September, if a tenant doesn't pay their full rent, each month the landlord must serve this 15-day notice to pay or quit, which has the language that the state wants you to have so tenants understand their rights. So this highlighted it that this is for the period September through January. And they will also each month, the tenants unable to pay rent, along with a new notice, will serve a blank declaration form. Again, each month the tenant can't pay full rent. They should return this signed declaration form, note the date and how they sent it, and try to pay at least 25% of the month's rent. So it's possible for a tenant who's been impacted for a long period of time, the first period and the second period, that they may get from their landlord like 4 notices and 2 blank forms. The tenant shouldn't panic. This is just, it doesn't mean something's going to happen. The landlord is fulfilling their obligation, and all the tenant needs to do is sign this declaration. This declaration is available in multiple languages on the state's website, which we will get to, as are the forms here that I'm showing you. Okay, next slide. So here is the website I was talking about. If you type in housingiskey.com, just don't put www, it will error out. This is going to take you to this page. It's put out by the Department of Real Estate and the state website. Under tenants, if you click on the form, that's where you're going to find all the declarations in multiple languages. Landlords has some information and resources for landlords, including the 15-day notice, the notice that should be given by the end of May 30th. And there is this interactive tool that can help you, guide you through what, either if you're a landlord or tenant. So the orange box in the middle, if you click on that, it's going to ask you a series of questions. Are you a tenant? Are you a landlord? And at the end, it's going to give you a report of supposedly all the things that apply to you. I would still double check and make sure that jives with your understanding. I think it's been reported that there might be some little issues with it. But it should give you a report of all the forms that you should be serving on your tenant if you're a landlord. It will also tell you of what programs are available if you fall into the small landlord category, which Charlene will talk about in a little bit. I'm also highlighted at the top of this page that you can select a language and have it at least translated by Google Translate, which is not perfect, but if you're in contact with somebody who, sometimes it helps, even if they know some English, to read something in their own language. So there is that too. And hopefully this website will get more robust and accurate as time goes on. So next slide. I'm going to turn it over to Charlene to talk about options available for landlords.
Okay, so I wanted to talk about the relief both under AB 3088 as well as some federal protections small landlords have when their tenants are not able to pay rent and they're impacted by COVID. Okay, so the definition for AB 3088 for a small landlord is a landlord who owns no more than 4 rental units with no more than 4 units in each rental unit. So you can have a 4-plex, you can have up to 4 4-plexes. As long as there's no more than 4 units in that property, you qualify under this definition. Okay, and the properties are, it is not required that the property be owner occupied. In other words, if you have a 4-plex, you don't have to live in one of the units. They can all be rental units. Next slide, please. Okay, so what are the options available? So obviously, if you have a situation where your tenant is not able to make the rent, that can significantly impact your ability to make your mortgage payment. And so one of the reliefs that are out there is what's called a mortgage forbearance. And a mortgage forbearance is a temporary suspension or reduction of your mortgage payment during this hardship period of time. Now, under the federally backed mortgages, we call these GSE mortgages, which will include FHA mortgages, VA mortgages, Fannie Mae, Freddie Mac. Frankly, the federally backed mortgages account for roughly 2/3 of all the mortgages in the country. So there's a better than average chance that your loan may be a federally backed loan. You have protections with these forbearances to forbear or defer your payment for anywhere from 90 days, in some cases all the way up to 12 months. The forbearance amount is going to be not forgiven, obviously, but put to the point where the forbearance ends. And the way the forbearance is going to work is they're typically going to give them in 90-day increments that can be renewed, sometimes up to a year. What happens at the end of the year, well, let me back up for a moment. If your loan does not fit into that federally backed mortgage, mortgage servicers are still providing a lot of leniency and these forbearances as well. Sometimes they're not providing the forbearance for as long of a time. It may only be, 2-3 month periods rather than the 12 months. But what happens with the mortgage at the end of the forbearance period is that amount will become due, but typically not instantly. They're going to give you some time to work with getting it paid back. In many cases, there may be the option to put it to the end of your loan. So if you, for example, if you had a 6-month forbearance and you had 21 years left on your mortgage, you would now have 21 years and 6 months. So you don't have to come up with this large amount. Other options can be a mortgage modification. A mortgage modification is a permanent change of one or more of the terms of the mortgage. This can include addressing the interest rate. It can include putting the loan past due amount into a new loan and re-amortizing your payments, or as I said a few minutes ago, it can include putting the past due to the end of the loan. Now, while you are on this forbearance, if you're eligible to get this forbearance, if you have your account escrowed, if you have the property taxes and the homeowner's insurance included in that monthly mortgage payment, you have the option, and it's frankly a fairly good idea if you have the income to pay the property tax and the homeowner's insurance portion of your mortgage, so that when those taxes become due, frankly within just a short time, your mortgage company has the amount to pay them. Okay. The process of getting these forbearances is a lot easier than you may think. Almost every mortgage servicer on their website has a COVID page where you can click in, and it's pretty easy. It's frankly just maybe half a dozen to a dozen questions related to your inability to pay the mortgage. Now, one thing that's really important to point out, this is not an option for people who were past due on their mortgage prior to the COVID-19 pandemic. You have to have been current at the time the COVID-19 pandemic began. You don't necessarily, if you are applying now, it might be understandable that your mortgage might be delinquent if you haven't been able to collect rent. But at least as of February or March of this past year of 2020, you need to have been current. Also, it's important to point out, if you are approved for a forbearance, most mortgage companies and all government-backed mortgages are typically not charging you any late fees, and they are typically not reporting late to the credit bureaus. So you should not have a negative impact on your credit score. And the other thing I'd like to say is, if you have any questions about whether your loan is a GSE or government-backed loan, it can be easily looked up. If you have trouble with that, please feel free to call us at the number listed here at the bottom of this slide, or contact us through our website or email.
Great. Thank you, Charlene. Thank you, Emily and Michael as well. We did get some questions that came in during the speaker's presentation, and we were able to answer those. So if you have any questions at this point, you can put them into the Q&A, or you can, at the bottom of your screen, you have a little hand figure. You can raise your hand and we can allow you to speak your question. Here, the last slide just gives you the information for where you can go for help. So the Law Foundation, our number for the tenant and landlord counseling services, and the mortgage counseling number. Looks like got a question here. From Ann Mark. Are you able to speak, Ann? I think we can hear you, Ann.
Oh, okay. Okay, good. So my question is, what are the landlord penalties under the CDC?
You mean landlord penalties, Ann?
Pardon?
I'm not sure what you mean by landlord.
Well, I just in one of the presentations, it talked about that there are penalties. I mean, if the landlord tries to evict the tenant, if they violate the law, basically.
So there's potential if a landlord probably willfully violates the order. There could be potential criminal and penalties up to $100,000 or $250,000. Michael, you can corroborate or correct me if I'm wrong. But that's,
sorry, just
yeah.
navigating the unmute. That's exactly right. So, one thing to note though is it's $100,000 per violation. So that's the charges.
Considerably more than what there are retaliation penalties, I believe, in the state law too.
Okay, thank you. Thank you.
Thank you for your question. Are there any other questions? So again, you can do the raise hand feature. It should be at the bottom of your screen there, or type into the Q&A.
And there's no small questions. This is a lot of info.
Yeah. Okay, looks like we've got a hand raised here. Go ahead and unmute you, Emma. Okay, it's telling me, Emma, that you're using an older version of Zoom, so I'm going to promote you to a panelist so you're able to speak. Emma, go ahead.
You're muted.
Here we go.
Can you hear me now?
Yes.
Okay. For landlords who don't have any mortgage, do they get any kind of help if their tenants don't pay their rent? Do you think the government will be thinking about that, or they just say, too bad?
Well, I believe that there were a bunch of bills that were being proposed and working their way through the legislature during the summer, and some of them did involve some form of relief for landlords who are impacted. But with this urgency legislation that is AB3088, all those other bills are, for lack of a better word, dead now. But there were lots of promises by the legislature that they're going to take up all these unanswered questions in the fall session. So I would, you can hold out some hope that this is a known problem. It's statewide. I imagine there would at least be some tax relief of being able to claim it as a loss. But in this bill, there's nothing addressing relief really for anyone. But there was legislation working through that had some interesting proposals that probably would have benefited some landlords, some people think.
Okay, thank you. I have another question. So this is addressing landlord and tenant, and there is a different kind of renting. It's like similar to an Airbnb. Do you address any of those type of business thing at all?
So anytime a tenant is, or someone is staying in a place more than 30 days, they are a tenant. And these laws would apply. It doesn't matter how they rented.
Okay, so they
through what platform. So if they,
yes, they are a tenant. I see. Okay.
Michael, does that do you agree
Yep.
with?
Yeah.
Great. Thank you, Emma, for your questions. Looks like we've got.
So I think I answered this in that, but I'll make it clear. So the CDC is the Center for Disease Control. It's a federal agency. The question was, what is the CDC? So the last order that we were talking about, the executive branch, I think authorized so the Central for Disease Control is an agency under the executive branch, meaning the president. They were authorized to issue their own health order, and that's, you know, in some sense a higher level of law because it's coming from the federal government and it applies to all states in the union. But it was very explicit that if there are laws in place locally at a state level that are more protective, that those laws would apply. I hope that answers.
Thank you. Looks like Sandra has her hand raised. I'll go ahead and allow you to talk. Sandra, you have to unmute yourself.
Okay, can you hear me?
Yes.
Okay, so I have a situation I know about where a tenant is not paying any rent to the landlord, but is illegally subletting and receiving rents from other people. Does anything in what we've discussed address that kind of issue?
Michael, do you want to?
Yeah, so, I mean, I guess nothing prevents that tenant from claiming the protections. However, like people are having an unauthorized occupant on the property could be a basis for cause eviction. So, yeah.
But they have to follow all the just cause rules, whether or not, because all the just cause rules apply to if they're not subject to a local law through February 1st. So if they believe it's a breach of contract or illegal subletting or stuff, they still have to take steps to put tenants on notice and give them an opportunity to cure. But if the tenants still have, or the occupants still have potentially some protections from the CDC order as well through the end of the year. So there's a lot of hurdles there.
Thank you.
Thank you, Sandra. Well, we've got about 5 more minutes left until we reach the end of our time here. So if you have a question, again, please feel free to raise your hand. I think Anne has another question. I'm just going to unmute you, Anne, to see if. There you are, Anne. If you have another question, feel free to speak now.
I do. One thing I wanted to say is that there is help for landlords in various cities, and San Mateo County has a program specific to helping COVID-19 impacted owners. It's being run through the San Mateo County Credit Union, and in Gilroy and Milpitas, we also have a program that will help tenants and landlords with the unpaid rent. These are cash programs. And other Project Sentinel staff, I think, can be helping answer questions about those services. But so my question has to do with if an owner doesn't give the let's say unpaid rent notice to the tenants on a monthly basis, can they give it to them like after 2 or 3 months of unpaid rent, and still enumerate each month, but give it to them well, on a cumulative basis rather than an individual monthly basis?
Yep. Yeah, that's totally fine as well. Certainly no need to send one every month, but you are allowed to do that if that's your preferred.
And what happens if a tenant doesn't get their notice back to the tenant within the 15 days? Let's say they get it back, somehow they just don't understand the 15 days, they get it back in 20 days.
Yeah, so in that case, the state law actually sets up a process where the tenant can instead send that form to the court, and then the court will have a hearing on whether or not that that failure to provide the declaration in time was the result of mistake or excusable neglect or any kind of like a misunderstanding on the tenant's part. And if the court finds that it was a mistake or due to some sort of excusable reason, then the court would dismiss the case actually.
And allow the tenant to then go ahead and comply with the law.
Right.
Okay.
Yeah.
Thank you very much.
Thank you for your question. Again, we have just a few more minutes here. If anybody has a question, feel free to ask now. I will mention that at the end of the presentation, when you log out, you'll get a survey link. So if you'd be willing to fill out that survey link for us, greatly appreciate that. And again, if you're able to share your email address, we can send you a copy of tonight's presentation. So I'm not seeing any other questions. I did want to mention again that one of our case managers, Mark Thomasy, is here and willing to stay on the line if anyone from Milpitas has any specific Milpitas questions and would like to find out more information about the rules and regulations in Milpitas. So if you are a Milpitas resident and you'd like to do that, again, please go ahead and raise your hand. Looks like we got one question here from Rick. Are there any circumstances under which the landlord can evict? Michael, would you want to answer that?
Sure. So I think you know, the set of circumstances under which a landlord can evict are any circumstances that include kind of a something the tenant has done. So anything that would be considered a for-cause eviction. So if the tenant is, you know, causing a nuisance or causing damage or, you know, threatening other tenants or conducting criminal activity at the property, those evictions can still go forward right now. The landlord does need to provide the tenant opportunity to kind of fix those behaviors if they want to go forward with an eviction, though.
Great, thank you. I think we have Sandra. I think she has her hand up again. I'll go ahead and unmute you, Sandra.
Sorry. Okay. Thank you. I was going to say that it would be great if Project Sentinel and the Law Foundation would make some of these standardized forms really easy to find on their websites. So just a suggestion.
Yeah, thank you. That's a good idea.
Yeah, we do have resources on our website, and are working on getting forms published. I think, you know, one thing to note from the tenant side is if you do want to provide, I know that there's a kind of desire to claim protections as soon as you can. So you can send in, you know, a signed declaration of your COVID impact to your landlord kind of proactively, but you also need to do that in response to any eviction notice. So, you know, even if you have the form on your own, you still need to respond to the notice is the caveat I would give there.
Thank you for mentioning that.
Okay, looks like we have Ben who's raised your hand. I'll go ahead and allow you to talk. I believe you have to unmute yourself first.
Hi.
Hi.
I've had inquiries from real estate agents who want to show homes, but the tenants refuse, claiming just they don't want to let anyone in because of COVID. Would that violate, or would that allow for evictions? Because, you know, even with any reasonable or even unreasonable accommodations.
That's a very subjective question. And when we get questions like that from either landlords or tenants, we first direct them to the public health order and what the guidance is for showings, because there has been. We encourage both sides to work together to figure out how best you know, things can be accomplished. So, like, is it possible for the owner to go in by themselves and do a virtual tour? But whether or not outright bar would be a for cause for, you know, denying right of entry, that would be up to a judge to decide. So we encourage the use of mediation during these, because, you know, the tenant may have some concerns, and maybe if the realtor or somebody understands them, and if everybody understands what the public health guidances, they might be able to work out some solution. But Michael, you can give the stricter version.
Yeah, I think that's actually what I would say as well. So, definitely encourage folks to work something out. I think, given the health concerns that are in play right now, really encourage everyone to be sensitive to working something out that keeps everyone safe.
Thank you. Thank you. And thank you again to everyone for their questions. It's really helpful and helps us think about this, this law in different ways and what the impacts are. So we really appreciate your time that you spent here with us tonight. Thank you again to Michael from Law Foundation, to Emily and Charlene from our organization, and to our partners for helping us get the word out about this event. Again, you can check our website and these contacts we have here on this on this slide for more help. And we'll be doing more of these webinars and as things develop. So it's okay not to know exactly what's going on. Things are changing, and we just really want to stress how important it is to educate yourself and arm yourself with the best information out there, understanding that it's a difficult time to be a landlord and a tenant. So thank you again very much. If any of our speakers have anything they want to sign off with, feel free.
I just want to say thank you again to Project Sentinel for hosting this event. I also want to say thank you to all the attendees, and to help us spread the word. If you have neighbors who have questions, provide them our resources, direct them to our phone lines and websites for more information. I think it's in everyone's best interest to know what rules are in effect right now.
And any feedback on what was confusing and what could have been better on the presentation would be very valuable, because it's been a chore to distill this down and make it understandable. And some of us have been living it too much. We can't put ourselves in the shoes of somebody who doesn't read tenant landlord law every day. So I encourage you to be as frank as possible in the evaluation.
Great.
Lastly, I would like to also say that if there are any landlords who find themselves in a situation where they need assistance with the forbearance or later on with a mortgage modification, our program does provide assistance with working with the homeowner as well as a mortgage company to try to reach either the forbearance or the modification. So again, please feel free to reach out to us.
Great. Awesome. Thank you again. And don't forget to fill out the survey once this ends. And thank you again to our speakers, our partners. Yeah, that was Asian Law Alliance at the Silicon Valley Independent Living Center, who helped us get the word out. So again, thank you for the collaborative effort. And until next time. Bye-bye.
So.